All setting, do I go back? Or stay in here?
You need to stay in here.
Stay in
You
here?
need to stay in here.
Okay, thank you.
It's not like a sensitive.
Y'all have cell phones, make sure they're turned off, please.
All right, and the inmates are coming up?
Yes, no, I've got them up here. You might bring them.
Yes, if you can bring them out. Thank you. Is there anyone who has somebody by Zoom? Miss Monday, Mondy? Okay. All right, Mr. Stenberg, who do you have? Could I see the file on Mejia, please?
Just need a trial.
Okay. It's Joseph Mejia. Why are you late for court?
I had to drop off my niece.
All right, you can't be late for court. You understand?
Yes, ma'am.
All right. State on Joseph Mejia, this is family violence. Norma, if you could call the family violence prosecutor. All right, counsel, you received all of the discovery.
Take the glory of them.
All right, can you check to see if there's a discovery acknowledgement in the file? How long you expect this trial to last? I mean, it's a third-degree felony, 3 days. All right, Norma, I need a jury trial date, family violence, 3 days. All right, your jury trial date is going to be January 14th. Your plea deadline date has expired. The court will not consider any plea bargain agreements with that good cause. Otherwise, you have to plea open to the court. Do you understand? Have any questions about anything? All right, once you sign the reset form, you'll be excused. Make sure you're here on time, okay? All right, thank you. You're welcome. All right, just remain in the courtroom till you get a reset time. I'm sorry, what?
King's Day?
No, not the 14th.
Oh, you said the 14th?
Yes.
Okay, I'm sorry.
Oh, no problem.
Thank you.
You're welcome. Just have a seat and your attorney will bring you your reset form.
Thank you.
You're welcome. All right.
I'm not done. I'm not.
Raymond, are you able to do an acknowledgement of discovery for Mr. Stenberg on Mejia?
Yep.
All right, thank you. All right, any defense attorney ready? Who is your client? Can I see the file on Delarosa, please? Yes, I thought they brought him up. He's in the box. All right, Mr. Delarosa, come down. Delarosa, come down. All right, court is calling 2023 CR 7787, State of Texas versus Anna Marie Delarosa. Can I have parties announced for the record for the state
State,
defense?
Ray Lopez for the defense.
All right, and are you Miss Delarosa?
yes, ma'am.
Did you review the document entitled Motion to Enter Adjudication of Guilt and Revoke Community Supervision with your attorney?
Yes, ma'am.
Did you understand it?
Yes, ma'am.
Are you the same Anna Marie Delarosa who was placed on deferred adjudication in 2023 CR 7787 for the offense of burglary of a building with intent to commit theft on April 30th, 2024 for a period of 5 years? Is that you?
Yes, ma'am.
All right, state.
Your Honor, the state wishes to proceed on violation of condition number 6 on or about the 10th day of July 2024. The defendant, Anna Marie Delarosa, departed Bexar County without the written permission of the court and or supervision officer in violation of condition number 6.
How do you plead to that? True or not true?
True.
We waive and abandon all of this, Your Honor.
Any objection?
No, Your Honor.
Did you understand by pleading true to violation of condition number 6, the court could find it true, grant the motion, find you guilty, sentence you up to 2 years in the state jail facility and up to a $10,000 fine?
Yes.
Knowing that, do you still wish to plead true to violation of condition number 6?
Yes.
Court will find violation of condition number 6 true. Is there a proposed agreement?
There is, Your Honor, it is to grant the state's motion, enter an adjudication of guilt against the defendant, revoke her community supervision, and sentence her to 232 days in the Bexar County Jail under Texas Penal Code 1244-8.
All right, so why would I follow this agreement? Because I'm assuming that's a judgment satisfied.
It is, Your
All
Honor.
right, why would I do that?
Your Honor, she's contesting the charges that she picked up in Medina County. She does admit though that she left the county without permission and remorseful for that. And is looking to put this matter behind her.
Oh, I'm not, just so everybody understands, I'm not considering anything else on the motion. I'm just considering violation of condition number 6. Has she done anything on probation? Has she completed anything? You want to raise your right hand? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am.
All right, you can lower your hand, state your name for the record.
Anna Marie Delarosa.
All right, what have you done on probation?
I reported to probation. I've also been looking for work, like as said on my probation. I had work in line, but considering that I left,
Why did you leave the county?
I had to go and pick up my sister-in-law from where she was at because she got stranded, so that was.
Why didn't you call probation and tell them, I need to go pick up my
I
sister?
mean, I didn't think it was an issue and a problem because I didn't think I was violating probation at that time. And she just needed a ride, so I went to go and get her. So I mean, I didn't see where there was a problem or an issue at that moment in time because it was just going and picking her up. And that was I didn't see that there was a problem.
Did you start on your parenting classes?
No, I have there was a parenting class that was in line for there.
No, my question is, did you start your parenting classes?
No, ma'am, I didn't.
All right.
But the reentry program does have those parenting classes, and so I just had to wait to get into that
Were
program.
you in felony drug court?
No, they said they denied me because I don't have no drug issues since 2017. My case wasn't related to drug issues.
And
I didn't
you're
come in
not
on no drug
employed?
charges or anything, so they drug court denied me because I have no drug.
Have you been
charges.
employed since April 30th, 2024?
Have I been employed?
Yes, since you've been on probation, have you ever had employment?
Well, my probation officer was supposed to check in with you because I have a history of working through a providing agency. but because you took that away from me, that's the only,
Oh, no, I don't know. Everybody knows I do not allow people to work as home health care providers when you're on probation for a felony. Everybody knows that. So my question is, have you had employment since April 30th, 2024?
no, so I was looking for.
All right, so that's a no. Did you report to probation
I
since
did
April
I
30th of
did
twenty
tell,
twenty-four?
yes, yes, ma'am, I did. And I was also calling the hotline like it was told to do. I was doing my conditions as followed. Yes, I was.
Any other questions?
And I also called my probation officer to let her know where I was at. I tried contacting her several times and stuff. So I mean, I did everything that I was supposed to do. I do have job lines followed as well when I get out of here too.
But you haven't had an employment since April 30th, 2024. Any questions?
Ms. Delarosa, did you complete your TAP evaluation? as
Yes.
ordered by the
Yes,
court?
ma'am, everything was done.
When do you recall doing that?
When I was incarcerated in Bear County. It was a top evaluation and then it was followed through drug court, which they denied me because like I said, they said because I don't have no drug history, there was no reason for me, for them allowing me to take that course.
And then, so you were released from custody in June of 2024, does that sound right?
Yes, ma'am.
Okay, and then, you were ordered to submit to drug testing in July of 2024, do you recall that?
For the phone.
Yes.
Yes, and I was calling every day like I was told up until the time that I got placed into Medina County. And then I was there for 4.5 months.
So are you aware that your probation officer stated that you failed to submit to drug testing on July 12th, 19th, and 26th of 2024?
Because I was already incarcerated.
You were already incarcerated in July. And then are you aware that your probation officer is alleging that you struggled with calling the UA hotline as you were instructed to do?
If I wasn't incarcerated, how was I able to call the hotline?
So when were you incarcerated?
July 12th, 2024.
But before that, are you aware of any that your probation officer is alleging that you were having trouble, calling in on the UA hotline?
Because I was already incarcerated. in July.
Before your incarceration?
There was no, I was calling every day. There shouldn't have been a reason why.
All right, any questions? Probation, what is probation's recommendation?
Judge, the court summary indicates they want revocation.
All right. Any objection to the court reviewing the court summary?
No.
Thank you. All right, thank you. The court is going to grant the motion, find you guilty. The court will revoke. The court will sentence you to 14 months in the state jail facility. You're credit for any time served. There's to be no contact with Veronica Garza or 1803 Macaulay, McCauley, San Antonio, Texas, 78224. And no contact with Jose Gutierrez, I'm sorry, with Grace Rocha and Jose Gutierrez. And Raquel Puente. All right, I'm going to show you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that document with your attorney? Did you understand it and sign it? All right, you have a limited right to appeal. That right to appeal is as it relates to the allegations in the motion, not the fact that you are on deferred adjudication. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, sir.
All right, good luck to you. Who's here on Robin Hernandez?
Hi, Your Honor, Robin Hernandez Huerta.
Yes.
Yes, that's me, Your Honor.
All right, if you all will come forward. And where's your client?
She is in custody. She is right there, Your
All
Honor.
right, if she'll come down, please. What are we here for in this case? Is this a motion to revoke? What is this?
Your Honor, it's a motion to enter adjudication of guilt. I was just retained for Ms. Huerta Monday and I set a motion to set bond. Because she is remanded without bond on the case. So I'm just asking the court to set a bond. I've already conferred with the prosecutor on this amount.
All right, court is calling 2023 CR 3442 State of Texas versus Robin Huerta Hernandez. Can I have parties announced for the record for the state,
Megan Galloway from State.
for the defense?
And this is Pauline Portillo for Ms. Robin Huerta Hernandez.
All right, defense is here on a motion to set bond. State, have you had a chance to review defense's motion?
Judge, I didn't.
All right, and is there a proposed agreement?
Your Honor, when I spoke to Ms. Galloway yesterday, she said that she would agree to $15,000 for bond. I believe the original amount was $5,000.
Is that correct?
The original amount was 3,000, Your Honor. Yeah, I have no objection to it.
All right, and this is a possession category 1 gram to 4 grams. All right, and what is the allegations in the motion? Because I don't have, could somebody give me a copy of the motion?
Okay, I'll give you my
Yes.
copy.
All right, thank you.
Yes.
All right, thank you. All right, so you're all in agreement with a $15,000 bond?
Yes, Your Honor.
And for the record, the court is aware of Ms. Huerta's history. Who is the judge who took your plea?
You,
I'm not sure about that because there's nothing here, and usually I write down things on the docket sheet.
Your Honor, if I may, I was at this point.
No, you were in this court, but there was a different judge. I think I have an idea because there is absolutely nothing written on here. And I have no idea what conditions, if any, were set. So just give me one moment. It's 2023 CR 3442. And the reason why I asked that is because I'm trying to figure out what conditions of your bond to set. So just give me one moment. Okay. All right. No, that's fine. Thank you. All right, the court is going to set your bond at $12,000. Court is going to order full GPS, waive fees, 120 sober meetings, in 120 days. And Norma, set this for a contested hearing the week of January 6th, please. January when? Put it for the January 6th.
Judge, I'm so sorry. I am
Yes.
actually gonna be out of the country that day. I'll be back
Ah,
the 7th.
Okay,
I have a letter on file. I'm so sorry.
all right. No,
Okay.
there's no need to apologize for going on vacation. Everybody needs vacation. All right, when is it set for contested? All right, it needs to be set for contested.
So the 13th or move it?
We can either do, we can move it the week of the 6th after you come back, or either we can do the contested on the 13th. Which would you prefer?
13th.
All right, so there will be a contested hearing then on January 13th.
Okay, thank you, Your
All
Honor.
right, thank you. And Norma, if you can make sure she has a reset form. Page is she on? All right, thank you. Cameron Hollingsworth. Thank you. Mr. Hollingsworth?
Usually no judge, the witnesses on that one.
Oh, Monday. Miss Monday? Monday?
Yeah.
All right, there's somebody on the Zoom that is.
Oh, yes. I'm sorry. I was
Oh
like,
my
I was like, Monday.
All right, so, and that's for your motion for the bail reduction?
Yes, Judge.
All right, before we get there, do you have all the discovery?
It hasn't been indicted, Judge, so at this moment, I don't believe I.
Oh, it hasn't been indicted.
And
Okay.
it was assigned to court already, so I don't know. Sometimes it is, sometimes it's pre-indictment court, so
Okay,
I just filed it within the court because it was assigned.
okay, no problem. All right, Miss Monday, if you could unmute, please. And start video.
Okay. Hello?
Oh, could you say something so I can make sure we can hear you?
Hello?
All right, just give me a moment. There's something wrong with the equipment on this end. Just give me a second.
Yes, ma'am. That's what I'm thinking. Take one, maybe this one. Right across there, so that it's kind of holding it in. It's still gonna be able to move, right? But that'll give it some safety. Okay. And I think just experiment, you know, like maybe try doing like through the workspace and have one crisscross here, one crisscross there. Oh, yeah. Yours is looks like mine. She says, no, thank you. Have a good assignment. Thank you, ma'am. Thank you. It's been great working with you.
All right, could you say something for us now so I can make sure we can hear you?
Hello.
All right, thank you. It's going to get feedback. There's something wrong with this equipment here today. All right, court is calling 2024 PF 19296 State versus Cameron Kenneth Hollingsworth. Can I have parties announced for the record for the state? Defense?
Attorney Alvarez, brother, Mr. Hollingsworth.
And are you Mr. Hollingsworth? Defense has filed a motion for a bail reduction. State, have you had a chance to review defense's motion?
Yes, sir.
Is there an agreement or no?
There is not, Your Honor.
All right, state, what are you requesting?
If I'm informed correctly, bail is already set at $15,000, and that seems to be appropriate considering the circumstances.
All right, in defense, what are you going to be requesting?
I'm requesting the bond set at 7,500, Judge.
All right. All right, then, defense, do you have any witnesses?
I do have a witness on Zoom right now, Your Honor. I think it's Chwanya. Monday.
All right, Miss Monday, can you raise your right hand for me, please? Do you solemnly swear affirm the testimony you give will be the truth and nothing but the truth, so help you God? Do you solemnly swear affirm that the testimony you give will be the truth and nothing but the truth, so help you God?
Hello?
I don't know what she said. It wasn't in response to my question.
Okay,
I couldn't hear you at first. I'm sorry, ma'am.
All right, do you raise your right hand? Raise your right hand. Do you solemnly swear or affirm that the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am.
All right, you can lower your hand. You need to turn up the volume.
over there.
All right, state your name for the record.
Twanya Mundy.
All right, you may proceed.
Ms. Monday, what's your relationship to Mr. Hollingsworth?
Girlfriend.
And was he currently residing you before he got arrested?
Was he residing with me?
Was he residing at your household?
No, he was staying at the Veterans.
And have you had an opportunity to try to post bail for Mr. Hollingsworth?
I tried, but I can't afford it right now.
And does Mr. Hollingsworth work?
Not at this moment.
Prior to getting arrested, was he working?
He was doing temporary, like day labor.
And do you know if he has any money saved in order to?
No,
And are you the only person that has money to post bail for him?
yes, sir.
And what's an amount that you can afford?
I have about $800 that I can afford to post bond bail for Mr. Hollingsworth.
And you've already reached out to a bondsman that said they would take that if the bond is reduced?
Yes, sir.
Is there any other family members that you've been able to reach out to see that they can help Mr. Hollingsworth at all for this bond?
No one's able to help at this time.
Is Mr. Hollingsworth, was he part of the military?
Yes, he was.
And was he going through the VA to get assistance for living?
Yes, he was.
And where was he staying?
It's the veterans. I can't think of the name of it, but it's located right off of Main Street by the Lubies. He went through the veterans atrium to get placement there.
And if he gets out on bail, is that where he would continue to reside?
I spoke with his caseworker, and she said that as soon as they can get a bed form, a room form, that they will accept him back. So I said that I would allow him to stay with me until he's able to get back into the program.
And how long has Mr. Hollingsworth resided in Bear County?
This time for about a year, almost 2 years.
Okay. And he would continue to reside in Bear County, you're stating?
Yes.
Do you believe he's a risk, a flight risk at all?
No.
That he would show up to all his appearances?
Yes.
Do you know if he had any prior cases that he was arrested for?
In the past, when I met him in 2020, he was going for a case of robbery, which he did TDC time for.
And are you aware if he made all those court appearances at that time?
I'm not. I just know that during the time that I entered his life, he was going to court.
Okay. And can you tell the court how much money you have after all your expenses that you pay?
After I pay all my expenses, I have little to none. Right now, I'm out of work due to a work-related injury. So the money that I have is money that I have saved.
Okay. And do you believe Mr. Hollingsworth's a threat if he gets out on bond?
No, he's not a threat at all.
I pass the witness, Your Honor.
State.
No questions, Your Honor.
All right, is this witness excused?
She's excused.
All right, thank you. You can go back in. Thank you.
Uh-huh.
Just one moment. Let me change the sound. All right, any further witnesses? All right, the court will hear argument.
Your Honor, Mr. Hollingsworth at the moment has been in custody since this arrest date. Prior to the arrest date, he was actually fixing to start a new job at Pluckers. Currently, he has no savings. The only family member that he had was Miss Mundy, who stated that as far as what she could afford, is to pay a down payment of $800 towards a bond amount. The bond's currently set at $15,000. After speaking to her, she's comfortable with paying, she would be able to afford a bond amount of $7,500. In addition to that, Your Honor, Mr. Hollingsworth is a resident here of Bear County. He's not a threat or a flight risk. If there's any other conditions that the court may consider in possibly reducing this bond, I'm sure he would abide by those, including any GPS tracking, any partial house arrest. He's trying to get back to work so that he can continue to provide for his family. I mean, additionally, Judge, he was seeking, he was staying through the VA at a place. And so he still has that place to stay if he gets out on bond. So we're asking the court, Judge, to reduce this at 7,500.
All right, I just have a few questions for your client that is related to any bond conditions. If I do lower his bond, can you raise your right hand? Do you solemnly swear affirm the testimony you give will be the truth and nothing but the truth, so help you God? All right, you can lower your hand, keep your voice up so that the court reporter can hear and I can hear. All right, have you ever had any type of mental health diagnosis?
No.
Have you ever been on any type of mental health medication? Have you ever seen a psychiatrist before? Have you ever in the past used any illegal substances?
Marijuana.
Anything? All right. I said in the past. Anything other than marijuana? All right. State any questions?
For Mr. Hollingsworth?
Yes.
No.
All right. Then any further argument, defense?
No further argument now.
All right, state.
Your Honor, so far, there has been no testimony or evidence other than Ms. Monday. There has been no testimony or evidence about any other family members of Mr. Hollingsworth. Any of those family members who have been contacted, what amount, if any, they would be able to contribute. So the idea that there are no family members who are capable of assisting him is an assertion that has not been proven. Additionally, considering that Mr. Hollingsworth has been convicted and sentenced for both robbery and assault, family choking, perhaps Ms. Monday does not have quite the estimation of his character that she should. So considering his criminal history and the lack of evidence put forward by defense counsel, the state renews its argument that 15,000 is appropriate in this circumstance.
All right, defense, it's your motion, so you have final argument.
Your Honor, Ms. Monday did explain that she is the only family member that he has here. And she's the only provider for him. So as far as whether or not there was any evidence provided by the court, she did state that she is the only person. There is no other family members here. He's originally from Indiana, is my understanding, and or North Carolina. Indiana, and she is the only family here. All the family members don't have money to help him or support him.
All right, the motion to reduce bond is denied. And counsel, if for some reason he is unable to make bond in the near future, just reapproach the court again.
Okay.
All right, thank you.
Thank you, Judge.
Excuse me, Your Honor.
Yes.
Thank you, Lord.
Jeremy Alvarez. Good afternoon. How's it going? Yes, it's good seeing you. All right, is this family violence or criminal?
Family.
All right. All right, court is calling 2022 CR 8631 State versus Jeremy Alvarez Perez. Can I have parties announced for the record for the state?
Ashley Jones for the state.
Defense?
Deborah Stantonberg for the defendant.
And are you Mr. Jeremy Alvarez Perez?
Yes, ma'am.
All right, we're here because the court received a supplemental report and there was a request to allow removal of GPS.
Yes, Your Honor.
All right. And is there an update probation other than the supplemental report that the court has received?
No update, Judge, except for, Ms. Burke has agreed, to represent Mr. Alvarez Perez in this proceeding. And we spoke with the state and they have agreed to amend GPS to tracking only, Judge.
All right.
That's correct.
And all parties are in agreement to not removal, but just for tracking only?
Yes, Your Honor, this defendant's been on GPS commercial for at least the last 5 months after having completed ISF or ISB and ISF and ISB.
Okay.
And then I just wanna, that's our agreement.
Mhm.
I wanna make sure tracking is the same thing to me as it is to the people who are in charge of the monitor.
Well, I will tell you, this is what it means to the court.
Okay.
He can go wherever he wants to go. However, if he's planning to go out of state or anything of that nature, you need to get permission from the court.
Because he works in state,
Yeah.
all and around the state.
No, he
And
can.
his boss is here too in case.
Oh, where is your
Yeah,
employee?
Mr. Camacho,
Hi.
that's his boss.
All right.
They build metal buildings.
Okay.
They get jobs all over the state.
Okay.
He's the supervisor for Mr.
Oh, wow.
Camacho. So the deal is sometimes they're there late finishing a job and they're in different cities. And so we just want him to not have a certain curfew. But he does not need to leave the state. And if they do get a job out of state, he can apply
Yes.
for permission.
All right. Well, I see that you've been doing well on probation, so I appreciate that. I see that you went on the third cross retreat, which I can never order that, but when people come to me and ask for it, I always say, yes, you can. And the reason why I can't order that is because it's associated with religion and we're not allowed to do that. So, but when defendants come to me and they say they would like to go, I say, sure. And I see you haven't obtained any more face tattoos. Okay.
Just a
Yeah.
new baby is coming, okay?
Okay, that is awesome. And I see that you successfully completed state ISF. That is good. So let me just tell you what I'm going to do. I'm going to follow the agreement to tracking. We're going to see how that goes. Don't mess up, okay? And you need to stay very vigilant about your sobriety. Don't backslide, because sometimes people will get in the habit, they'll say, oh, I missed a day, I'll just make it up the next day. And then you look up, you've fallen off track. So you need to make sure that you stay hyper vigilant, okay? And as your attorney told me, he has a baby on the way?
Yes.
Oh, is it a Christmas baby? When is the baby due?
February 4th.
Okay.
Oh, February 4th. Well, maybe the baby will say, I
No,
prefer to
that's
be
too
here on the
early.
14th.
That's too.
Yeah.
Your Honor, when he was just on regular GPS, they told him he could only work 48 hours a week.
Mhm.
And he had to be home by 5. I know I've already addressed the be home by 5. We don't want
No,
a
he's
cap on how many
tracking.
hours a week you can work either. Okay?
No, he's
Okay.
tracking. He can just do, you're free to roam about doing good things. Okay.
Thank you.
All right. Is there anything else?
No, Your Honor.
All right, then if probation, just stop by probation to see if they need anything else from you and continue with the good work. And you'll have to bring me photos of the new baby. Okay.
Thank you.
All right. Have a good one. And thank you, Ms. Burke, for coming in to take care of that.
And I'm still here to do a plea.
All right. All right, on that one, conditions are changed to tracking only. All right. What page is Alvarez on? All right, thank you. All right, and can you see where Michael DeLeon is, please? And could I see the parties on Robbins? Where is defense counsel? If I could see y'all in the hallway, please. Mr. Stevens, are you coming too?
No, I'm just watching you.
All right, could I see the files on Galvan and Lopez? All right, Tommy Lopez. Is he in custody? All right, can you bring him out? And is Luke Galvan in custody? And if he is, if you can bring him out as well. And they can go on the docket for the 19th. Well, let me ask you this. Do you want to put it on the 19th or you want to put it on the Friday? All right. Hello, sir. What's your name?
Lopez.
All right, Mr. Lopez, your attorney is asking that your case be recalled for Thursday. So we're going to bring you back on Thursday, okay? All right, thank you so much. And are you Galvan? Come down, please. All right, I wanted to let you know your attorney contacted the court. He's asking that your case be recalled for Thursday. So we're going to bring you back on Thursday, okay?
Yes, ma'am.
All right, thank you so much.
Right.
And who is the last person on the top row? Who is he for?
Oh, he's fine, and I'm here. Leave me.
All right, thank you.
Vincent Martinez.
All right, thank you. All right. So is Justin Guzman here or no? Hmm? Could I see the file on Justin Guzman, please? Okay. Okay, why do things keep appearing on the docket and they're not supposed to be on the docket? That's one of my questions.
They're just supposed to be on the docket. I think there was a breakdown in communication to get him on film from Atascosa County.
All right, so he needs to be bench warranted from Atascosa County. Recall it for January 23rd.
Morning, Judge.
Good morning.
I'm here on one roll list.
All right,
With
did
your-
Justin pull your file?
He's asking for permission to go ahead.
Oh, sure.
Oh, thanks, Judge.
Yes, all right, no problem. And Michael DeLeon said he's not the attorney for record, of record for him. So if you'll check with the MAC. Well, tell Mac that the defense attorney is saying that he's not the attorney of record, so they'll need to appoint somebody. All right, tell them they'll need to appoint someone then. Has the attorney been here on Justin Cowart? On page 3? Justin Cowart? He's in custody. Hello, are you Justin Cowart? All right, we're trying to get in touch with your attorney, Mr. Gomez. Have you had any contact with him?
It's been off and on.
All right, just give me a moment. And did you hire him?
Yes.
All right. Could I see the file on Justin Cowart, please? All right, just give us a moment. If you all will, they're going to keep you in back. Just give me a moment. I'm going to see if I can get in touch with your attorney to have him here, okay?
Okay.
All right, thank you. Yes, this is Judge. Justin Cowart. Oh, we have someone in our court, Justin Cowart. Yes. No, he's on the docket for today. Yes, because we're not gonna have. Yeah. Well, I'll tell you, if you want to go in, you can go.
Okay. Martinez.
Miss Ferguson. Do you have a cell number? We'll text you this. Okay, what's your cell? Oh, no problem. I just want to ask, like, who were the. I just want him to. Yeah, you're not. A little bit out of it, yeah. All right, thank you. All right, all right, here's some of the Zoom links to him.
Yeah.
You said she decided to and wait for it to do. And on the last page here. Okay. I'll go ahead and take a photo. All right, one Robles. And I believe this is criminal trial division.
Yes.
All right, so where are we on discovery, counsel?
There are, all the co-bans associated with the case have not been uploaded onto Veripig or e-discovery. The initial contact, as described in the police report, those co-bans are significant as to the allegations of either throwing something out or even a traffic violation.
Okay.
So the prosecutors agreed to obtain those and upload them. And then go from there. She's made an offer. We're in negotiations for that offer, and I have good communication with Ms. Robles. We talk almost every day.
All right, so other than the co-ban, is there anything else?
As far as I can tell, no, Judge.
All right, Ms. Ferguson, on this one, give me a reset date for 45 days. That should get everybody a chance. And if your attorney wants you brought in sooner, he'll let the court know. All right, so we'll come back on January 30th. And I will have that as a discovery date.
Okay.
All right, is there anything else?
No, ma'am.
All right, once you sign the reset form, you will be excused.
Thank you, Judge.
Thank you.
I've been doing good, Judge, 2 out on bond, you ain't gonna have no problems for me, huh?
All right, I appreciate that. Thank you very much. So do you have employment yet?
No, I'm on full GPS, house arrest.
All right, well, if your attorney comes forward and you all want to do something about employment, I'll consider that.
Okay.
All right, stay out of trouble.
Wait for me. All right.
All right, and the parties on Martinez. All right, if you come down. Who? No, I don't. I have Cowart. And I have Kevin Wright.
Tony Cantrell.
Hmm.
Tony Cantrell.
Oh, who do you have? Oh, can you just let him go before you
I
get?
want to.
All right, this was hidden. Hi, how's it going? You're just sitting there so patiently.
Well, I know, it's
That's
gotta wait around,
you, right?
but, it's like trained dog.
No. All right, so you have Mr. Wright.
Yes, ma'am, we finished his case about a week and a half ago.
Mhm.
State dismissed it, and I need additional funds to finish my bill.
And so you're saying, let me make sure this is in the system as dismissed because there have been some strange things happening with Odyssey. All right.
Do you have permission?
Oh, no, it's not.
You like that?
No, I do not. All right, it doesn't show as dismissed.
Okay, well,
So we need to make sure if that's supposed to be dismissed, that it's done. Do you know when it would have been dismissed?
like last,
Oh, they've attached it to me. Do you have a copy of the dismissal?
I do not.
All right, if you can make sure he gets a copy. Yeah,
Thank you.
you're welcome. Let me see. And then. There's
Judge.
that. You're welcome. All right, Attorney Burke,
Ready.
we will take you up.
Clock for 10.
No, I was like, why are you here? I thought maybe he was just coming to visit.
Well, he and I got to visit.
Oh, see, that is always good,
Of
right?
course.
All right, court is calling 2024 CR 010655, State versus Lou Vincent Martinez. Can I have parties announced for the record for the state
Alexandria Roberts for the state.
defense?
Deborah Stanberg for the defendant.
All right, and are you Mr. Martinez?
Yes.
All right, counsel, have you received all discovery? Did you review it with your client?
Yes, Your Honor.
Court will find that the state is in compliance with discovery. Mr. Martinez, did you review the application for deferred adjudication with your attorney?
Speak up.
Yes, ma'am.
Did you understand it and sign it?
Yes, ma'am.
Did you review the true bill of indictment with your attorney?
I told him about it.
Okay. Do you understand what you're charged with?
Yes.
All right, counsel, do you waive the reading of the indictment?
We do read, wait a minute.
State, are you proceeding on the indictment as presented? All right, Mr. Martinez, did you review the court admonishments and waivers with your attorney? Did you understand it? And did you sign it in all the appropriate places?
Yes.
Did you understand you're charged with assault on a family and household member with a previous conviction? That's a third-degree felony. Range of punishment is anywhere from 2 to 10 years in prison and up to $10,000 fine. Did you understand?
Yes.
If you have a plea with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you. Did you understand?
Yes.
All right, so here's the thing. I want you to focus and listen, all right? So the state has made you an offer. Do you understand that?
Yes.
I don't have to follow that offer. Do you understand that?
Yes.
If I don't follow your offer and give you something more than you bargained for example, they're offering you deferred adjudication. If I were to say, I'm not giving you deferred adjudication, I'm giving you a conviction, I am not following your agreement and I'm giving you something else than you bargained for, that's more of a punishment. Do you understand?
Yes, yes.
All right. If I were to do that, you can withdraw your plea. Do you understand?
Okay.
No,
Yes,
do you
yes,
understand?
yes.
You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent. Did you understand?
Yes.
Did you understand by entering this plea bargain agreement, you're giving up those rights?
Yes.
And did you intend to enter into a plea bargain agreement in this case? Did you understand if I were to grant your application for deferred adjudication, if for any reason you're revoked, I could sentence you up to 10 years in prison and up to $10,000 fine?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
Yes, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
Yes, Your Honor.
Do you believe he is currently competent and was legally sane at the time of the offense?
Yes, Your Honor.
Mr. Martinez, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea?
No, ma'am.
Anyone promised you anything other than the plea?
No.
Are you satisfied with the way you've been represented?
Yes, absolutely.
Are you a U.S. citizen?
Yes.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, ma'am.
According to the plea, there's a $1,500 fine. State recommends deferred adjudication. There's an affirmative finding of family violence. With an affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition. Did you understand?
Yes, ma'am.
With an affirmative finding of family violence, you're not allowed to be designated as primary custodial parent. Did you understand?
If you get a divorce, she's gonna be the primary.
Oh, okay.
Do you understand?
Yes, ma'am.
Knowing that, do you still wish to proceed with this plea?
Yes.
And did you understand that to be the plea?
Yes.
Defense is at the plea.
Yes.
State is at the plea.
Yes, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
I signed everything and she went over everything with me. So,
All right, did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
yes, ma'am.
Counsel, are there any such motions?
No, Your Honor.
Outside the agreement, the state is requesting that your community supervision be for a term of 3 years. There be 40 hours of community service restitution, no harmful or injurious contact with Deidre Martinez, the BIPP course, TAP evaluation, mental health evaluation and follow all recommendations. Did you understand those are recommendations from the state and the court does not have to follow those recommendations? Then to the offense as charged, how do you plead? Guilty, not guilty, or no contest?
No contest.
Okay,
We
thank
have
you.
something for you.
All right, thank you.
State's offering his prior, it's not a conviction, it was deferred probation for a misdemeanor. And before you even asked for it, we had both said, you offer it and I won't object.
All right.
Okay.
So, State, do you have any evidence to support the defendant's support the defendant's, plea?
Yes. State office states exhibit 1 and all attachments.
No objection.
All right, did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places? Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there'll be no live testimony. Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there's sufficient evidence to find you guilty. Court will defer finding of guilt as you've applied for deferred adjudication. Are you proceeding with sentencing?
Please, yes.
Anything you wish to say on behalf of your client?
My client is so sorry that this event happened and it'll never happen again. He expresses remorse.
All right, so I have a few questions for you.
Yes, ma'am.
So I read in the police report, I see that there's a request by the state that there be a mental health evaluation.
Yes, ma'am.
So have you been receiving mental health treatment at the jail?
Yeah, I'm taking the Prexa. That's pretty much it. I've seen the doctors and nurses, but I haven't seen specifically a psychiatrist or.
All right, when you're out of custody, do you have a case manager?
No, I don't. My wife's a disabled vet. She's 100% permanent total, and I'm just still getting on my feet, moving. So pretty soon, I should have somebody. Wait, a case manager?
Yes.
No.
You know, that's somebody to make sure that you take your medications and somebody that you can call and somebody that can sort of advocate.
So, yeah.
He wants one though.
Okay. So what is your history? Are you military or no?
No. I'm gonna be her caregiver. They just changed the law to where she can. I won't be able to be her caregiver. Why not?
I mean, I don't allow that. You're here for an assault and it's assault against her. I understand you were going through a mental health episode, but.
Can we can we delay that finding and present you more evidence on what her condition is, what she requires, what you would be required to do? Can you just hold that thought in abeyance and I'm happy to come back with more information.
All right, do y'all want to come back on a different day for sentencing?
No, I want to do sentencing today. He's in jail.
Well, see, the thing about the no harmful or injurious contact,
Yeah.
I don't do that on family violence cases unless I have a chance to speak with the complainant, because I don't know what's going on in the household.
Well, actually, he's going to Haven for Hope when he gets out.
Okay, all right. It's a $1,500 fine. It'll be probated, affirmative finding of family violence, 3 years deferred adjudication, regular reporting by Zoom or in person, regular random UAs. There's to be no contact with Deidre, DEDRA.
But we need to contact her.
That's my wife.
No, but what I'm saying is I cannot, and I want you to sort of see it from my perspective, right? If I have somebody who's accused of beating up somebody else.
Keep her.
All right, that doesn't make it, yeah. So you've been accused of assaultive behavior before, and you've been on deferred for that, and it was family violence. I don't know who that was against. All right, so,
Don't talk about that.
yeah, so now you're before me, and there's another assaultive offense. Now, I know the state is saying no harmful or injurious contact, but guess what? I don't know the complainant. I haven't had any discussions with the complainant. The only thing I know is what's in the police report that has been submitted to me. Now, if you all want to go forward with sentencing today, I'm going to order no contact. If the complainant comes in, I can talk to her at another point. But when you leave here today, it's going to be no contact. And if you contact, that's going to be a violation.
If you give me your. We'll do it today, and I'm gonna file a motion to see you later.
Okay. All right, there's to be no contact with Deidre Martinez.
Even though you're not following our plea agreement, right?
No, I mean, that's outside the plea.
Oh.
Yeah.
Do you want to make it inside the plea?
I can tell y'all this, y'all put this inside the plea bargain agreement, I'm not gonna follow it.
Okay, that's fine.
So,
I'll file a motion.
all right, so there's to be no contact with Deidre Martinez. The BIP course. There's to be a TAP evaluation
When we finish.
and a mental health evaluation. That can be done out of custody. Follow recommendations. If for some reason the recommendation is for inpatient treatment, you can bring it back and we'll have a discussion about it. Proof of employment or SSI within 45 days. There's to be no employment as a home health care provider or with minors. There's to be no unsupervised contact with minors. There's to be field visits 1 time per month for 6 months.
He has kids with his wife.
And what are their ages?
14, 15. I have one that's 18 and one that's 24, 25.
All right. And there's going to be 40 hours of 80 hours of community service restitution.
So I'll file a motion for you to reconsider all those things after I talk to his wife.
Probation, is there anything else?
No, Judge.
Is there anything else you need from the court to be successful?
Yes, he's gonna get his lawyer to do that for him.
All right, but do you need anything? Because
Yes.
she's not going to be reporting to probation, you are. So is there anything else that you need help with?
No.
All right, did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney?
Yes.
Did you understand it and sign it?
Yes.
Because this is plea bargain agreement, because I followed your plea bargain agreement, and because, yeah, I did follow it. And because you waived your right to appeal, you do not have your court's permission to appeal. Because this is an affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition. If you have a question of what those items are, you need to speak to an attorney. You understand?
Yeah.
We can go off the record. In this court, to be successful on probation, communication is key. If there's an issue, let your probation officer know. If you feel they're not addressing it, you can always come back to the court. Do you understand?
Yes.
All right, and I'm sorry, Bashan, can you refer him to Center for Healthcare Services? All right. All right, thank you. Yeah, Deborah, I'm gonna let Jamisa know you're up in here in Zeta Blue.
I love blue. And you have it on today too.
All right, so on Robbins, we'll be ready just as soon as probation goes over his conditions, then we'll be ready to take you up next.
Thank you.
You're welcome. Hello.
Hi, Your Honor.
Hi.
Could I speak to the court reporter about your
Sure. All right, are the parties ready on Valentino Peralta? All right, court is calling 2000. All right, court is calling 2024 CR 010370, State of Texas versus Valentino Peralta. Can I have parties announced for the record for the state?
Andrew Harris, Salem.
Defense?
Daphne Previty for Sean Brown's office, Judge.
And are you Mr. Peralta? Are you Mr. Peralta? Counsel, have you received all discovery? And did you review it with your client? Mr. Peralta, did you review the application for deferred adjudication with your attorney? Did you understand it and sign it?
Yes, Your Honor.
Did you review the true bill of indictment with your attorney? Did you understand it?
Yes, Your
I
Honor.
showed him a copy of it, Judge. We're getting his own copy.
All right. And counsel, do you waive the reading of the indictment?
We do.
State, are you proceeding on the indictment as presented?
Yes, Your Honor.
All right, did you review the court admonishments and defendant's waivers with your attorney? Did you review this document with your attorney?
Oh, yes, Your Honor. I'm sorry.
All right, did you understand it and sign it in all the appropriate places?
Yes, ma'am.
Did you understand your charge of possession of a controlled substance, penalty group 2, 4,400 grams? That's a second-degree felony. Range of punishment is anywhere from 2 to 20 years in prison and up to $10,000 fine. Did you understand?
Yes, Your Honor.
If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand? Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent? Did you understand by entering this plea, you were giving up those rights?
Yes.
And did you intend to give up those rights and enter into a plea in this case?
Yes, Your Honor.
Did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 20 years in prison and up to $10,000 fine? Counsel, has your client been able to provide you with any defenses?
Yes, Judge.
Do you believe he has a rational as well as a factual understanding of the charges against him?
In my opinion, he does.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, Judge.
Mr. Peralta, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, Your Honor.
Has anyone promised you anything other than the plea? Are you satisfied with the way you've been represented?
Yes,
Are you a U.S. citizen?
yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Could you bring Cowart out, please? Cowart, yes. All right, did you review the plea bargain page with your attorney? Did you understand it?
Yes, Your Honor.
According to the plea, there's a $1,500 fine. State recommends deferred adjudication. They're taking in consideration 711951. Did you understand that to be the plea?
Yes, Your Honor.
Defense, is that the plea?
Yes, Judge.
State, is that the plea?
Yes, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes,
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
yes, Your Honor.
Counsel, are there any such motions? Outside the agreement, the state is requesting that your community supervision be for a term of 2 years. There'll be a TAP evaluation and 200 hours of community service restitution. Did you understand those were recommendations from the state and the court does not have to follow those recommendations? Then to the offense as charged, how do you plead? Guilty, not guilty, or no contest?
No contest.
State, any evidence?
Yes, Your Honor.
Any
We have no
objection?
objection, Judge.
Mr. Peralta, did you review the waiver and consent with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there'll be no live testimony. Did you understand? Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments, and the court will review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. Court will defer finding of guilt as you applied for deferred adjudication. Are you proceeding with sentencing?
Happy to waive the PSI, but how do you do the tap? Does he just go and whatever they assess, if he doesn't like it, we come back?
Yes.
Okay, that's fine, Judge.
All right, anything you want to say on behalf of your client?
Judge, he has changed his friend group since that night, and he's in a committed relationship with a young lady now and trying to do much better. So he's had trouble finding work. So if there's something available, some kind of job counseling through probation, he'd like to avail himself of that as well.
All right. Who is Walter Rueda to you?
That was an old friend of mine. I have no contact to him.
And Albert Mendez? I'm sorry, strike that. That's the, oh yes, Albert Mendez.
Same thing, man.
Anna Alonso
Same thing, man.
and Tobias Juarez.
Same thing, man.
All right, there's to be no contact with Walter Rueda, Rueda, Ana Alonso, Lonso, Albert Mendez, Mendez, and Tobias Juarez. How old are you?
20, man.
How far did you go in school?
I graduated 3 months early.
All right, so what are you planning on doing with the rest of your life?
I want to go to trade school for HVAC,
Okay.
or either go through the military for it, but my lawyer just told me I might have to get done with probation, then go to the military.
All right, well, if the military accepts you, then I'll consider early termination. You can let them know.
Thank you.
All right, 2 years deferred adjudication. There's to be no contact with the persons previously mentioned, Walter Rueda, Ana Alonso, Albert Mendez, Tobias Juarez. Regular reporting by Zoom or in person, regular random UAs, TAP evaluation out of custody, follow recommendations, proof of employment within 45 days. There should be plenty of work, seasonal work.
Yes, ma'am.
There's to be no employment as a home health care provider or with minors. 200 hours of community service restitution. I'll waive those hours if you obtain a trade school certificate. You say you want to do HVAC. If you complete that program, then it'll be waived. Or if you decide to go to college.
Thank you, Your Honor.
You're welcome. There's going to be field visits 1 time per month for 3 months.
What is that? Fine.
Oh, that's probation is going to come out to where you reside.
Okay, yes,
And do you reside by yourself or with someone else?
with my parents.
Okay. All right, probation. Is there anything else? Is there anything else you need from the court to be successful?
No, ma'am.
All right, and I'm sorry, and taking in consideration 711951.
May I approach, Your Honor?
Yes. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it? And did you sign it?
Yes, ma'am.
All right, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand? All right, we can go off the record. You're gonna have to be very careful in your life with who you hang out with, all right? And this, okay, In this court, to be successful on probation, communication is key. If there's an issue, let your probation officer know about it. If you feel they're not addressing it, you can always come back to court. You understand? All right, good luck to you.
Thank you. Your Honor.
All right, Norman, can you have him zoom back in? Tell him we're ready for him. Dumbass. Oh, and counsel, if you want your client to sit with you and y'all can discuss things, you're more than welcome to do that. Deputies, can you have Mr. Robbins sit with his attorney? He's in the box.
Your Honor,
Yes,
is there any more CPD business?
yes, there is. It's Mr. Cowart.
Judge, I believe that charge, an online.
Let me see.
Defendant wants to know us.
Yes, let me see. Oh, it is. Is that a special prosecutor?
Prosecutor.
All right, thank you.
It's like Mueller.
Okay.
Your Honor, may CTD be excused from the court?
Yes. All right. All right. Thank you so much. Norma, were you able to reach him? All right, Mr. Cowart, if you'll come down. Mario, are you able to hear us?
Yes, Judge.
Okay, awesome. All right. So, Mr. Cowart, the reason why your attorney is not here is because Odyssey has been doing some strange things. So he thought it was set on the 19th, and I have no reason to doubt that, but he did jump on to Zoom, okay? So, counsel, on this one, I know that he came back as confident. Is that correct, the last time we were here?
That's correct, Judge.
All right. Do you know if you have all of the discovery?
I believe I do.
All right. And was an offer given to you?
Not yet.
All right. What I'm going to do is I'm going to require the state to tender an offer. So if you'll get in contact with her, my understanding it's Mulliner.
Yes.
What I'm going to do is I'm going to set this for a plea deadline date. And I can set it the week of January 6th.
January 6th. For plea deadline date?
Yes.
Okay.
All right. So what date is good for you?
We said January 6th, right?
The week of January 6th.
Oh, the week of January 6th. Okay, let me check real quick. Can we do Thursday the 9th?
Yes. All right, so we'll bring you back on January 9th, okay?
Okay.
All right, do you have any questions?
No, Your Honor.
All right, thank you so much. All right, thank you for zooming in. We'll see you on January 9th.
Thank you, Judge.
All right. All right, everyone, just give me 5 minutes for a short break and then I'll take your matter up. And if you could make sure I have the Robbins file, please.
That's your cell phone.
Oh, everyone, please stay seated. It makes it easier for the court reporter to hear. But if you'll just make sure you speak into the microphones. Okay. Oh, and that one, defense, if you'll put it on your lapel, that is for the court reporter to hear you because she wears headphones. And the other one is for me to hear you. You have a question? Oh, I have no idea. I don't know. All right. Court is calling 2022 CR 117 dash. Well, it's actually 2022 CR 11724. State versus Jordan Robbins. Can I have parties announced for the record for the state?
Eric Rodriguez and Lauren Scott for the state, Your Honor.
For the defense?
Keith Hampton.
All right, and are you Mr. Robbins?
Yes, ma'am.
Oh, you can remain seated. Thank you so much. All right, we're here because defense has filed a motion for new trial and is requesting a hearing on the motion for new trial. So we're here to have a hearing on the motion for new trial. State, did you review defense's motion?
We did, Your Honor. Before we begin, we would just like to make sure our objection is noted on the record for having this hearing. We do not believe that Mr. Robbins' motion establishes reasonable grounds to have the hearing, and so we just wanted our objection.
All right, and you want to expound upon that?
Yes, Your Honor. So in order to be entitled to a hearing, a defendant must show reasonable grounds that his motion for new trial is not entirely determinable from the record. And we believe that the record in this case, including Your Honor's own observations, and as well as the affidavits that both parties are going to submit, establish that reasonable grounds do not exist for holding this hearing.
Okay, and so it's the court's understanding, defense, that you were not intending to call witnesses, you just wanted to go forward on affidavit?
That's true for the movement, which is myself and the state. we've agreed, I think, completely on the exhibits. There'll be 10 exhibits from the movement, which are pre-marked, and they've been given copies. There is a withdrawn affidavit, Claude Martin, which was attached to the motion. And then there is the agreed stipulation between the defense and the state regarding the defense attorney, John Ford. And in response to the argument that this isn't determinable from the record, the two things that I'm going to talk to the court about today is first, the jury instruction, which is determinable from the record, but the other is about the events surrounding bikers against child abuse, and that is not determinable from the record. But it can be explained by affidavit. So and the state has a couple, I think just two affidavits, which I'm also not objecting to.
And Your Honor, if I may, I don't believe we are objecting to any of Mr. Robbins's affidavits, with the exception of the one that was provided by the juror, Mr. Joseph Kura. And the reason for that is it's a partial objection, Your Honor. And the reason for that is Ms. Scott and Mr. Saldana and I spoke to the juror yesterday, and a lot of the information that he details in the affidavit was told to him by the defense investigator. And so I have it written down here, the specific lines, but there are portions of this affidavit that are not within his personal knowledge based on that conversation we had yesterday.
All right, and let me ask you, the information that you say that you've obtained from the juror, did you let defense know what that information was?
Your Honor, we sent an email to defense at
They did. I agree. They liked them. Yeah.
No, the reason why I ask this is because I love for the record to be extremely clear. And so, because many a times I receive things from the fourth court that happened years ago, before I was here, before any of you were here. And then it just makes it difficult to track down things that they're requesting. So that's why I want the record to be extremely clear. And you mentioned that you spoke to the juror that's listed in defense counsel's affidavit.
Yes, Your Honor.
All right.
And I emailed Mr. Hampton at 4:08 p.m. yesterday about the conversation. So, and Your Honor, do you have a copy of the affidavit?
No, I do not.
Judge, can I suggest that I'm in movement and I'd like to commence the admission of exhibits? We're getting a little ahead of ourselves.
Well, what I like to do is I understand, I've read what you submitted. I've read the factors for consideration that have all been submitted. So what I like to do is I like to go through whatever argument everybody has, to go through it one step at a time. So you'll get a chance to address it. They'll get a chance to address it. So the first thing is with the juror that's listed in the affidavit. And can somebody tell me what exhibit number that is, or what?
It is Movements Exhibit 10.
Okay.
And the marked copies, this is also, I'm sorry, it was not attached to the motion for new trial.
Okay.
Only the investigator was, because I couldn't get his on time. We were at the 30th day.
Okay.
Kind of an unusual posture, but at any rate, we then did get the signed affidavit from the juror, and it's marked, I have it here, and it's marked Movements Exhibit 10.
All right, so,
Approach and-
yes. And do you have a copy, or is that the only one you have?
No, I have 20 copies.
Okay, yes. And if you'll have the court reporter mark it if it has not been marked. Okay.
So that I'm tendering Movements Exhibit 10, which is the jurors full affidavit.
Okay, counsel? Oh, I see where it's marked. All right, so with regards to movements exhibit number 10, State, did you review movements exhibit number 10?
Yes, Your Honor.
All right, so with regards to movements exhibit number 10, the court will review that. Just give me a moment. All right, the court has reviewed movements exhibit number 10. And State, do you have a corresponding exhibit with this or no?
No, just objections, Your Honor.
All right. Then the court has reviewed movements exhibit number 10. I'll hear objections.
And as I had said, Your Honor, we spoke to this juror yesterday, and there are specific portions of this affidavit that come from information that he learned, both one after the trial was over, and two from a third party. That third party being the defense investigator. So specifically, the state is objecting under Rule 602 for lack of personal knowledge. In paragraph 2, the sentence that begins, "I was later informed."
Which page are you on?
Second page, Your Honor.
All right, you may proceed.
And so the portion where the juror says, "I was later informed," that one, the defense attorney received a shoulder bump. That sentence and following sentence, the juror did not have personal knowledge about these incidents, and so we would object to that reason.
All right. Defense?
Judge, I think you can sift through, I'd move for admission of the entire affidavit and leave it to you to ignore that which is not relevant or which does not express personal knowledge. And I think you're capable of doing that, so I move for the admission of the entire affidavit. Those are his words. Some of this stuff in the affidavit, I agree. You know, he for example, he takes issue with being on YouTube. Well, that's got nothing to do with the motion for new trial. But I think you know that. You know, it's not anywhere in the motion, and but that's his affidavit, and so I would move for full admission of it. And my intention is to speak only about that which is relevant to the motion for new trial.
All right, so with regards to movement exhibit 10, counsel, which parts of movements exhibit number 10 that you believe have, well, are irrelevant to the court's making a decision?
It might be better to just point out what is relevant, and it is the paragraph that discusses his interaction with members of the Bikers Against Child Abuse.
And which page are you talking about, counsel?
That's on page 2. It's probably got it. Am I right about that?
I think that would be the beginning portion of paragraph 2.
Okay.
So that would start with on several occasions. Is that what you're saying is related to the motion for new trial, or whether or not the court should grant it or consider?
Yes. This is the governing rule of evidence, Rule 606B. And it is, you can't really hear from a juror except in limited circumstances. And one of them is the juror can testify or give an affidavit related to any outside influence being outside the evidence that's being presented. So it's that paragraph of his affidavit that's really relevant to the motion.
So let's do this. So let's start with page 1 of this affidavit. So is there anything on page 1 of this affidavit that is in any way relevant to your request for a motion for new trial? Yes.
Yeah. Well, certainly his name, his affidavit that establishes it, that he was a juror, that
Okay.
he was aware of the charges, all of that's relevant. His disagreement and wish for a new trial is something you've got a right to consider as a judge. So I think it's relevant in that sense. So I think the first 2 paragraphs, which is my name is Joseph Andrew Cura.
No. I understand that the general affidavit, his name, I understand that part because we need to know who it is. I'm talking about the body, the true body of the affidavit. For example, the first paragraph in the body. Yes, you would want to think that this person is talking about your client and this was the trial he was here for. But I've had many sleepless nights. How is that relevant to a motion for new trial?
Your discretion, your authority to order a new trial is broader than my motion. So this is something that you can consider that is beyond the motion, but it is not part of my motion.
Okay. All right.
And the state wouldn't object to that. Sorry.
Yes.
Yes, we think that 606B would prevent the admission of his, I guess, regret for lack of a better word.
Okay. All right. So if you all would like, this would make this hearing go so much faster. If y'all could review together movements exhibit number 10. Counsel, I understand that your argument is, court, we'll leave it up to you to consider whatever you want to consider from the motion. From the affidavit. I understand that. But I would prefer if you all would speak to each other, review movements exhibit number 10, and let's see what exactly is in there that is related to anything. For example, hypothetically, if someone were to say, I came over to the court and it was raining that day and I was running late. To me, that has nothing to do with the motion for new trial. So if you all could go through your exhibits, starting with exhibit number 10, and if you all can agree, I know state your objection is it shouldn't be admitted at all, but if you all could agree on what specifically has anything to do with the motion, your request for a motion for new trial.
Judge, we have done that. And I think I know what you're getting at.
Mhm.
And I think, well, let me recount what we did. We did it by email, which is paragraph by paragraph. and they stated, hey, we've got a problem with this one, this one, this one. So it's faster to say the one they don't have a problem.
All right, so here's my question. Did you all both come to an agreement on what was relevant potentially to a motion for new trial and what was not?
Essentially, I can do that right now, and I think it is the entirety of paragraph 2. I may be overstating it. I think the state was in agreement with what is marked, not paragraph, what is marked in the affidavit as number 2, which is a long paragraph. And it has to do with the influence of bikers against child abuse, people wearing the yellow shirts, influencing him. So I think, and they're going to correct me if I'm wrong about this, but I think we can agree on 2. I was about to say, I think we can agree on 3. They spoke to the juror actually last. I haven't spoken to him since they spoke to him. But paragraph 3 would also be proof of an outside influence. So I'll let them speak for themselves, but I think those 2 paragraphs are the ones they could agree are relevant and admissible to the motion for trial.
And it is correct that our only objection to that second paragraph that begins, the courtroom was full. Our only exception to that paragraph was the portion that we had discussed about, I was later informed about this after the trial ended by the defense investigator. That's the only portion of that paragraph we're objecting.
All right. So I don't see how things that people, well, jurors, things that they discover after the fact is relevant to a motion for new trial.
Right, but I think we are in agreement with everything except what he is saying, what he learned. Yeah, it's the paragraphs. I was later informed, and I also learned.
So how's
Those 2 paragraphs that they're objecting to under well, the grounds they've already stated, and those don't go to the motion for new trial. So we're in agreement about that. So I think paragraphs 2 and 3, minus those 2 sentences, are relevant to the motion.
all right, and then only paragraphs 2 and 3?
Your Honor, we also have an objection to paragraph 3, and that's the paragraph that's marked number 3.
Okay.
Because that also violates 606, because it discusses events that took place during the jury, not how an outside influence affected them.
Oh, I see. Yes, I can agree with that too. It's actually the first sentence of what's marked as number 3. He is talking about the deliberations. The request for statements, you already know about that. That's on the record.
All right, just one moment, please. Is there a notepad over there, please? All right, thank you.
Now, I think we're actually in agreement with just paragraph 2 minus those 2 sentences. That is what is relevant to the primary issue in the motion for new trial.
All right, so and movements exhibit number 10,
Yes.
the relevant portion, of course, the introductory sentence of who the juror is and that they were here for this specific case. I can see how that would be relevant, so we can know that they are talking about the same case. And then therefore, counsel, are you saying that paragraphs 3 are not relevant?
I'm agreeing to pointing out in agreement with their objection. I understand it. I'm still moving for the admission of all of it. And then you pick the portions that you think are relevant, since
Okay.
you can take anything into account and order a new trial.
But you are,
But in obedience to your direction, we are in agreement with paragraph 2 minus those 2 sentences. I think that's, if you're gonna limit, the consideration to the motion, just what's in the motion for new trial, in paragraph 2 minus those 2 sentences are what we're in agreement.
all right, so you all agree that paragraph 3, or what's labeled number 3 in movements exhibit number 10 is not relevant, and number 4, is that correct?
Yes, Your Honor, our same objection would be the number 4.
All right, are you in agreement with number 4 not being relevant?
Well, not relevant to the issue of outside influence, and that's true.
Okay, so then that would just leave number 2, correct?
Number 2 minus those 2 sentences.
Those 2 sentences, we're not objecting for the purposes of considering it for the hearing, but in not objecting, we're not also conceding to the truth of it, if that makes sense.
Yes. Just give me one moment to review number 2, please. So the question on number 2 that goes into the second page where it states, I was later informed. You all agree that the court should not consider that, am I correct?
That's what the state is requesting.
Okay. And then I also learn that some family members of the defendant not to consider that as well, correct?
Correct.
All right, so this is what I want parties to do with regards to movements exhibit number 10. I, of course, have the complete movements 10. I would like you all to provide us a movements exhibit 10A. And if you all can redact what you all agree that's not relevant. All right, so if you all could do that now, and then we'll move on to the next issue. Yes. Yes. Okay. We won't do anything till you come back.
Judge, while we're waiting, we have 2 affidavits that have already been tendered to defense.
Okay.
If we just enter those to the record.
Oh, just wait one moment till his client comes back.
Before that happens, may I speak to Ms. Spicer?
Sure. All right, just give me one moment.
Thank you.
All right. All right, everyone, please be seated. All right, we are back on the record. So were you all able to redact the parts?
Still working on it.
Okay,
But Your Honor, I do have the two state's exhibits.
all right, and that's the address, movements exhibit 10?
Yes, Your Honor. Ma'am.
Yes. And counsel, have you had a chance to see the state's exhibit?
There are
Correct.
two states.
Okay,
Yes, Your Honor.
Exhibits, and I don't have any objection to it.
all
Two
right.
affidavits, I think you should identify.
Yes,
Okay.
this is State's Exhibit number 1, affidavit of Deputy Pedro Mejia, and State's Exhibit number 2, affidavit of Marina Winter.
All right, thank you. Call Anna and see if somebody can come with a dolly. Yes.
Judge, while we're redacting, can I offer some more exhibits? The first 5 are actually just screenshots.
Sure.
And they don't have any objection.
Okay.
That's correct.
And what's being offered is
Exhibits.
1,
Yep.
2, 3, 4, 5.
And the dates, these are screenshots from the trial from YouTube,
Okay.
and they're offered to show the bikers in the yellow, also to show the one witness that was on YouTube, which was the mother, Alex,
Okay.
wearing yellow, just as they did last week at the hearing on stacking or concurrent sentences.
All right. So in movements exhibit number 1. I do see the witness that you're referring to. And it appears that there's some person in the background behind state's table wearing yellow. And movements exhibit 2. It appears that
1 through 5, they're different dates. They're just showing you the date of each trial.
all right. So movements exhibit number 1 is dated Wednesday, October 9th. And it shows the witness in a gold color and an audience member in the gallery wearing yellow. And then there's movements exhibit number 2, which appears to be another exhibit dated October 9th, which shows approximately 4 people or more in yellow. And then movements exhibit number 3, October 10th, shows more people in yellow. And movements exhibit 4, dated Friday, October 11th, shows more people in yellow in the gallery. And movements exhibit 5, dated October 14th, shows persons in the gallery wearing yellow. And states you have no objection to movements exhibits 1, 2, 3, 4, and 5?
That is correct.
Okay. They'll be admitted.
Judge, since we're still working on it, offer movements exhibit 6 and an agreed stipulation. Movements exhibit 6 is the defense attorney's John Floyd's affidavit. The agreed stipulation number 1 is a follow-up question by the prosecution to him via email that were memorialized so you can easily read it. So I'd offer those 2 since they're both concerning John Floyd.
And no objection.
All right.
The stipulation is signed by both parties.
All right, thank you.
And it is the original.
All right, thank you. So in evidence without objection is movement exhibit number 6 and the agreed stipulation number 1. And also taken into evidence without objection is respondents exhibit, states exhibit 1 and states exhibit 2. And I call that because that's what the exhibit stickers say. All right. And that's admitted without objection.
And they have the redaction and they've marked it 10A. And either one of us can offer it.
All right.
That was at your direction.
And counsel, are you in agreement with 10A movement?
other than, the motion that I've already made, that reflects, I think, what you wanted and what we could agree on.
All right, so movements 10A is admitted.
The only remaining, affidavits are movements exhibit 6,
Uh,
7.
Just one moment. So movements 10A is admitted for the court to review and not movements exhibit 10.
Well, can you, I would move for admission at least for purposes of the record, movements exhibit 10.
All right. Any objections for admitting that for purposes of the record? All right. So it will be admitted as movements exhibit 10 will be admitted for purposes of the record. However, both parties have agreed to the redactions in 10A, which is movements exhibit 10, but redacted and it's labeled as 10A.
And finally, the last three exhibits, movements exhibits 7, 8, 9. 8 is the affidavit from Josephina Obregon. Movements exhibit 8 is an affidavit from Kristen Jefferson. And exhibit number 9 is the affidavit of Tammy Robbins. And I don't think there's an objection from the state on those either. That's correct.
All right.
Offer those.
Thank you. Then movements 7, 8, and 9 are admitted.
Thank you.
And just give me a moment to review that. All right, I've reviewed those. Any other exhibits?
No, those are all, I think, all of the exhibits for everybody.
Any exhibits from the state? Any other exhibits? All right, the court will hear any argument.
I'm going to direct my argument to just 2 points raised in the motion for new trial. I won't belabor the first one because it's well joined in writing between the defense and the state. But the fact is that the prosecution should never have even attempted to persuade this court to give a lesser included instruction. It's clearly an error, and it was objected to by Mr. Floyd. It was a good objection, and you should not have instructed the jury on the lesser included. They weren't entitled to it. So I think the only solution there is a motion for a new trial. You would do the judges at the Court of Appeals a big favor by taking care of this up front rather than through an appellate process, a lengthy appellate process, in light of the clarity of the error. It's, under the test, the exclusive test, that instruction should never have been given. You directed a verdict, and which is another issue in motion that I'm not going to belabor that. But you did that, and then the state persuaded you to give them a lesser included instruction on decency. That should not have happened.
I don't know if the proper term is persuade. I hear both sides of the argument. People present their case law and I make a ruling.
So there's that. And that's, I would ask for a new trial so that it would be free from that clear error. The other concerns the bikers against child abuse. I didn't look for this. I went, when I learned that the trial was televised through YouTube, I went and watched the portions of the trial that were available. And that's when I started asking the question, what's the deal with the yellow shirts? I have no problem with bikers. I myself have been the statewide attorney for the Banditos, and they do charitable work, and it's real, it's legitimate, and it's nonviolent. That's not what happened here. The bikers that were involved in this trial, whether you knew it or not, and I assume you do not know that out in the hallway, it's bad enough that they are staring down witnesses, they're blocking them from going into the bathroom, they're assaulting the defense lawyer, Mr. Floyd. That's bad enough. But when they begin to make a concerted effort to influence the jury, when you have the affidavit that proves they did, staring down this juror, that it's a violation of Mr. Robbins' right to due process, the right to a fair trial. I have to wonder if the elected district attorney of Bexar County is aware that his office has married a self-appointed volunteer militia to involve themselves so deeply in criminal cases. I was shocked at that. And that is from the state's exhibit, Marina Winters. You'll see in her affidavit that she confirms the depth and scope of their involvement in this case. And it's not good. There are many cases out there, particularly Texas, especially between the years of the late 19th century up through the 1930s. The mob was the KKK showing up. And you got cases that condemn that. But there's an even larger issue, which is that justice has to also satisfy the appearance of justice. And you do not have that in this case. You've got affidavits that establish defense lawyer is being assaulted, people are being blocked, they're being intimidated, they're being stared down, and a juror, and all you need is one, was clearly influenced by that. And so if you establish as a matter of due process that a juror was influenced by their outside efforts, which he was, then a new trial should be awarded without those influences, free of those influences. And that it's just, again, I'm astonished that this went as far as it did. This is it's not, he did not get a fair trial. And I think that's all that I have to establish for you to have the basis to order a new trial. Your options are three. You can deny the motion, you can grant it, or do nothing and or take it under advisement or whatever, and it will be overruled by operation of law next Friday. But I would, again, urge that the court order a new trial in light of the clear errors and prejudice of Mr. Robbins in this case.
All right, state.
Your Honor, we also don't want to take up too much of your time.
Oh, no, here's the thing. I'm here till 5 or later, however long this take, I'll be here.
So I guess to start out, I do want to talk briefly about the lesser included offense issue. It is well established that the state can request a lesser, and because it's not in our written response motion, I'll go ahead and cite it here for the record. Since Gray versus State, that's 298 Southwest 3rd 644. The state can request a lesser. It's well known, and it is also well known that indecency of the child is a lesser included offense of aggravated sexual assault. And so I'll rest on that for that portion of the argument. But when we're getting into the presence of the Vipers against child abuse in the courtroom, before we get into the actual allegations in the affidavit, what I do want to say is that what these affidavits show is that none of this conduct was hidden to defense counsel. This didn't happen outside of their presence. This didn't happen in a situation where they were completely unaware that this was going on, even if all of the allegations in their affidavits are true. And so the purpose of the preservation requirements that both parties have is that if something is going wrong in the middle of trial, the attorney's job is to let you, the court, know about that so that you can use your authority to correct the situation before it gets to this point. We have had a jury hear all the evidence in this case. We have had to re-traumatize a victim by having her come in and testify. The jury has heard the evidence and they have deliberated and came to a unanimous verdict. And now defense counsel wants to bring up this conduct that they knew about, and the affidavits established that. And so there is case law cited in the state's response motion that you cannot grant a new trial on that basis. But if we do get into the facts of what the affidavits show, if you look at Mr. Currow's affidavit, nowhere in there does it say that the conduct that took place encouraged him to change his vote in the deliberations one way or another. And nowhere in that affidavit does it say that other jurors expressed fear to the point that they also changed their vote. And so what we have here is that the jury did not see a lot of this behavior, or any of it, and this court is aware of how it runs its own court, right? And so we've seen that when members of this club do come into the courtroom, this court will ask them to remove their identifying cuts, their insignias, and it doesn't stand to reason that this court would at least knowingly allow spectators to try to influence the outcome of the case. So Mr. Hampton is correct. The legal objections will obviously be litigated. But as far as the factual allegations that are made in these affidavits, he simply has not met the burden to show that he was harmed to the point where he is deserving of.
Can I add a couple of
Yes.
side thoughts? With regard to the lesser included, Your Honor, you know that even if you were to agree with Mr. Hampton as to count one and the lesser included, there were still 2 additional counts. So even if you agreed with his argument in the first issue, the second count and the third count would still stand. So even the remedy should have been, if you agree with him, that we just strike count 1 and still have counts 2 and 3. And as far as the yellow shirts, I think that the state just wants to make sure that we note for the record, and I think we did it in our response, is that we're not conceding that by putting into the affidavit, we're not conceding that the yellow shirts were in toward outside influence. In fact, we're arguing that they were not in the outside influence. Any pressure that the juror may or may not have felt was his own internal pressure, and that's what jurors have to deal with all of the time. Simply because they have to deal with internal pressures does not mean that there was an outside influence. And second of all, even if we assume that the yellow shirts were an outside influence on Mr. Serra, the court reviews the outside influence to see how it would affect a hypothetically reasonable juror. So it's not whether it affected Mr. Serra or not, or any of the jurors in Mr. Robbins' case, but would a hypothetically reasonable juror have been affected by the audience members that were here. And I think, Your Honor, to Mr. Rodriguez's point, you remember you were here, and there were as many family members on the defense side as there were on the state side. To say that one created more influence by spectating and watching the court, watching the trial proceedings, we could say the same for the defense, right? I mean, there's just a lot of people that watch these types of trials, and that's why the rules exist, that we don't go behind the jury's verdict, we don't inspect the jury's verdict, we inspect the jury's verdict, and they simply just haven't listened to their verdict in this case.
All right, it's your motion, so
Yes.
I'll allow you final argument.
You bet. Two things. One is a huge difference between a bunch of people who are watching a public trial. That's fine. And I know that you had to have been aware of them because I believe one of the affidavits say that, and they just, I think, stated that you have them take their vests off. Well, both of these are missing the point. It would have been better if they had kept their vests on, because it doesn't show that they are part of a team with a team color. If I brought his family in, everybody to wear a blue shirt or some other insignia, that's the same thing. That's identical. That's not what happened. So you can't compare a bunch of people wearing a yellow shirt in solidarity with the accuser and her mother, who are also wearing the team colors. That makes it worse, not better. That was not lost on the juror. The juror confirms that he saw the yellow shirts and that they talked about it during breaks. So you don't have that. The Supreme Court long ago, addressing mob type tactics in courtrooms, stated that it's in my motion, the integrity, which is really what we're after that every bit as much as a fair trial, must exclude, quote, influence or domination by either a hostile or friendly mob. There's no room at any stage of judicial proceedings for such intervention. Mob law is the very antithesis of due process, and that's exactly what you have here. And you should, and finally, on the first point, yes, you can strike the first count, but I don't think that that accomplishes what both these points lead to, which is to ensure that he gets a fair trial, which he wasn't given due to these errors and due to this outside influence, that you should order a whole new trial. This needs a do-over, and it needs it now and not later.
All right, thank you all. All right, and I will let you all know something by Friday.
Judge, one last thing.
Yes.
I filed, I guess it was on November 27th, a motion to unseal the juror records. And whatever your decision is, I probably won't be able to do it between now and Christmas, but I want to continue to talk to the jurors, but I don't know who they are. We figured out one of them, and that's why we produced that affidavit. The others could be anybody. So I filed a motion, and there is an attached order, and I'd ask for you to unseal the juror records so that we can continue to talk to the jurors about this.
All right. Do you have a copy of the motion? I don't have it in my file.
Yeah, sure do. I just marked on it.
That's
But
okay.
yeah, you can have it. I've got, it's in my computer.
All right.
Got plenty of
Right. State, have you had a chance to review defense's motion?
Yes, Your Honor, we have also filed a response to that. And so we would object to the release of.
Just one moment. Let me see if I have the motions. Because I don't believe I do. All right, I found your response to unsealing the record. And then I have the reply from the movement. Have you all received the reply? All right, okay, I'll hear argument.
And so, Your Honor, our primary objection is that if you're going to unseal personal information of a juror, there needs to be good cause. And in Mr. Hampton's response that focused on the case that we cited focused on jury misconduct. But the primary focus of that case law is there needs to be a firm foundation. And what we have here is that there was one juror who believed that people in yellow shirts were there to intimidate the process, I believe, by the words he uses in the end. The state argues that that does not rise to the level of firm foundation to allow what amounts to basically a fishing expedition. And we don't believe that Code of Criminal Procedure, Article 35.29 authorizes that. There has to be more of a foundation if we're going to allow jurors information.
All right, any other response from the state? All right,
My
response?
is, I'm not fishing. You have more than enough basis to let me talk to the other jurors. You have a juror who has signed an affidavit about his experience here. And we are aware, I don't know if the court is, I don't know if the court goes back and talks to the jurors or not. Some judges do, some don't. But this was a close case. Yes, they got their verdict, but there was a process there. And we want to talk to the jurors really about if their experience mirrors the jurors' experience. That's a basis. That's not fishing. So I'd ask for you to unseal the record so I can figure out who these other jurors are.
You know, I think we asked our review grant the defense solution, we also could ask for a copy of the juror's information to have the same opportunity to. But again, we stand by the fact that Article 29 is not part of the court to.
All right, so what I'll do with regards to your request to unseal the juror's record, I will give you all my ruling on that on Friday. Counsel, are you from out of, we can go off the record, are you from out of?
I'm Austin. At Boston.
All right, if you want to, you can appear by Zoom. Otherwise, I can just, I'll just make my ruling, fill it out, and the clerk will forward it to however you all want to do it. Friday, our docket is a little bit out of control. I've been told we have 90 people or something on the docket. Thursday. Oh, Thursday, our docket is out of control. So what I'll do, if you want to zoom in, you can zoom in. And we can have your client by Zoom as well, or either we can have him in person. So just let the court know. So I'll let you all know on Friday, my decision on whether or not to unseal jurors' records.
Your Honor, since you're taking down some of this, can I give you a case that didn't make it into our response and I gave a copy to you?
Sure. All right, thank you. All right, everyone, we'll enjoy. We'll be at recess. And counsel, if you need to speak to your client more,